Welcome, everyone. We are going to talk about copyrights and trademarks in the metaverse. And I have just a phenomenal panel with me here today. I am so thrilled about this group that came together. So unlike in the last panel where Sandra kind of put the same question to each of the panelists, I am expecting each of these four folks to go in dramatically different ways because obviously there is tons of material to cover and so much to talk about here. It's really rich and really constantly changing landscape. CIP Squared had a roundtable on IP in the metaverse this past July, and we did this for 2 full days in a row. I know a couple of you were there, others of you weren't able to join us, but so this conversation is building on that one in a lot less time. So I'm going to kind of hand it off and get out of the way, and I would love to start with Daryl Cendali, who is a partner at Kirkland and Ellis, and frankly just a renowned expert in trademark and copyright law. I've been aware of you and your work, Dale, for probably since I was in law school. So it's an honor. That's true for all 4 of my panelists, but it is an honor to introduce you and ask you to kick us off.
That's great. Thank you. Of course, that makes me look a little old, but nonetheless, I'm teasing you. All right, so we're here to talk about the metaverse. So the first question is, what is the metaverse? First answer is, we're not so sure. It could be lots of things. The concept is some form of immersive environment, and that you could have a virtual reality immersive environment. The Gartner Group, that one of those think tanks, says the characteristic should be, it should enable interaction, it should be interoperable, immersive, and be able to manage identity and support the creator economy. Okay, but there are other kinds of things that could fit too in that definition. They've also predicted that by 2025, 25% of everyone in America at least will spend an hour a day in some form of metaverse. I don't know if that's necessarily true yet, but it doesn't take long for technology to go viral and to catch on, and that could happen at any point with this. Now, the other question is, all right, so we're not quite sure exactly what the definition is. Well, what metaverses or metaverse do we have now? And the key thing there is that there is no one metaverse, and that the sandboxes, I use that descriptively, the sandboxes of metaverses that are out there are proprietary. And that will create different results, I think, at least, as a matter of law. So what do I mean by that? It's not like the internet, which started out as this, governmental, quasi-governmental thing that everybody kind of shares in. For the metaverses, companies need to spend time and money to put something together, and they can do it in different ways and have their own rules. So people probably know that Meta, previously known as Facebook, has the Meta Horizon workrooms and the Meta Horizon worlds. There's Sandbox, there's Web3's Meta Hero, and various other folks are thinking of things. Apple this summer announced that it was going to come out with some form of metaverse, and often these metaverses are attached to the idea that there'll be some form of cool goggles that you can use to play them. But not necessarily always, because one of the meta versions is something that you can also play in 2D on your laptop computer. And there's a lot of talk, well, maybe Fortnite from Epic is kind of like a metaverse in some way. But the point, though, is these are proprietary platforms where people can set their own rules. And therefore, terms of use become really important. One of the things that we were asked to talk about is, well, so what about IP? What about disputes? How does that work? How's that going to be resolved? Well, to the extent there's a dispute between a user of the metaverse and the company, often there'll be terms of use that will decide where you go or how you go about that. So, for example, in Meta, it says that everything was to be resolved in the Northern District of California. For Sandbox, it's to be resolved in Malta as the place of exclusive jurisdiction. I haven't been to Malta, but could be fun, So put that on your list. These terms of use, of course, can only bind the user, the player, and the company. They would be party to a contract, and I'm not going to talk about click-wrap law or anything like that as to how it would apply. I commend to the court the Zipper case for Take-Two that we won on a motion for a preliminary injunction that did enforce those kinds of terms of use in a at least in the gaming context. So then the other question would be, all right, what do you do then in terms of, and I'm focusing more on trademarks, what do you do then to enforce your trademark rights? What can you do? What law should apply? Well, basic thing is the law will apply. I don't think that we're going to end up in a situation like people said about the early days of the internet, where it would be this new world where no IP would apply. I don't think that's going to happen. But I think that because of the way these platforms are structured, you will end up with, some of them will probably have takedown provisions where you can contact them. Sandbox does. The Meta one, as far as I can see so far, has not put something like that up there. That could be a way of resolving things. But then the other question is, well, is it the only way? Could you file a lawsuit? What would be your claim? And that becomes a second issue. One of the things that's been debated a lot by trademark lawyers is, do you need to get a trademark registration that includes virtual uses? INTA's considering this question. Some companies are getting registrations for virtual uses. Some think if I have my regular use, I can, in my real world, that's good enough. There hasn't been an exact case exactly on it, but the closest one is probably the Hermes versus Rothschild case, which was an NFT case, where the people making the Birkin bags, Hermes, didn't have a virtual trademark registration, or that covered, they had a real trademark registration, but not one that covered virtual goods. But they were unhappy about the NFT, which was a virtual good. And the court wasn't concerned about that because it still thought that people would be confused, and that would be good enough. I could certainly see if I saw a virtual world and, I don't know, Mickey Mouse was walking around, I might be confused about that, regardless of whether somebody had a trademark registration that said that. The more challenging thing, and to kind of wrap up on this, might be, okay, you might have a claim, and you may not even need potentially your new sophisticated trademark registration, though it wouldn't be bad to have one from a client point of view if things develop. But there could be issues, especially if you don't go with whatever platform takedown issues that there may be out there. Who the heck do you sue? Because, sometimes people you can't find out their name, you don't know where they are. You might be able to use pre-suit subpoenas and things like that potentially to try to find out. But that could be an issue in terms of if you did have a claim, where could you find out who to go after and where would you go to do it? So bottom line is, I think that trademark law will apply to these different metaverses. I suspect that the terms in use and the people operating these metaverses will have an incentive to make IP law work and not make their metaverses confusing or infringing places. But exactly how that's going to happen, stay tuned.
Great, thank you. I want to next introduce Troy Dow, who was actually with us in July for that conversation about copyright and trademark in the metaverse. Troy is Vice President and Counsel, Government Relations and IP Legal Policy and Strategy at the Walt Disney Company. I know we have some students in the room. If you hear me say that and you're like, that sounds like my dream job, then I have to say, yeah, I agree with you.
Thank you, Alex. Thank you for inviting me to be a part of this. I'm glad to be able to especially follow up on the discussion that we started in the roundtable earlier this summer. So I was asked to talk a little bit about the copyright issues in the metaverse. And I'm glad that Dale went first because Dale posed the question and talked a little bit about a question that is the number one question you have to ask when you are asked that question, right? What are the copyright issues that apply in the metaverse? And the first thing you will hear back when anyone is asked that question is, well, what do you mean by the metaverse, right? That answer is going to be different depending upon what that looks like. And I think as Dale has articulated really well, that may look like a lot of different things. There may not be just one form of metaverse. There may not be one just sort of iteration that we may see all sorts of things. So I brought some of my toys with me. This was my first foray into the metaverse. This was my Disney Playmation. These are my Hulk Smash gloves and my Tony Stark Iron Man glove, right? And this was a foray into, we called this Disney Playmation. This was actually turning my house into the metaverse, where my kids would run around and one would be the Hulk and one would be Iron Man, and there'd be a little something hidden somewhere in the house that would use Bluetooth and an app to give them missions, and that they would be connected to these devices, and they would become those characters and run around the house and try and fulfill their mission. And there'd be like actually a little thing that scooted around the house that they had to find and conquer, and you had certain superpowers, right? You could do a force repel, you could do a Hulk smash, and you use your tools. Anyway, for the day, you were the Hulk or you were Iron Man, right? That was their introduction into the metaverse, right? And I think the idea of all of this, regardless of the version of the metaverse that you're thinking of, is to create an immersive environment. And that can mean different things in different places, different ways. And how copyright law applies and what the questions are is going to kind of depend on what that looks like, right? Is the metaverse somewhere that you walk through a front door and you're in the metaverse, right? And where is that? Is that, sort of worldwide, the different alternate reality of a world, and now you interact with people and as an avatar and you do different things? Or is it that you walk out of your house and you put on a set of virtual or augmented reality glasses, and now all of a sudden the metaverse is sort of imposed on top of you, so that the things that you see around you are the normal things you'd see, but all of a sudden you've got a droid walking next to you helping you in some conquest that you're looking at, right? You might be walking through a theme park and all of a sudden what you're used to seeing may be changed or augmented in certain ways, and it creates an environment that's more immersive for you and allows you to do things that you couldn't do just in the real world meat space. And so a couple of things that I think are interesting to think about on the copyright issues side, right? One is, I think the first threshold issue is to say, what are the comparisons, right? What are the analogies we make? What's the difference here between this world that I'm seeing and the real world that I live in, right? I know what the rules are that apply in the real world that I live in. Do those rules make sense in this new world that I'm in now, right, in this metaverse environment? And to the extent they do, are those the right rules? Do they work in that environment? Or is there a reason why in this environment you need new and different rules? And I think the temptation is always to just say, well, we ought to just set, the old rules ought to apply in the new space, right? We're here talking in this conference particularly about the first sale doctrine. We've seen for many, many years discussion around a digital first sale doctrine, and shouldn't we just take the rules that we're used to in the analog space and put them into digital space, so that if I acquire a digital asset, shouldn't I be able to treat that the same as a physical asset in terms of my ability to dispose of it and other things? And the question, I think, is, do those analogies hold? Right? Whether those analogies hold are going to depend very much on what the metaverse is in the context that you're talking about. But a helpful frame for me in looking at this is to go back now many years. I see David Carson. He will remember this because this goes back to the Copyright Office now some 20 years ago, where the Copyright Office was charged with doing an analysis. There was a new law called the Digital Millennium Copyright Act that had been enacted, and the question was, what impact was that combined with the effects of new digital technologies going to have on things like temporary copies and the first sale doctrine? And so the Copyright Office did a report where they analyzed that. And they started in that same place, which is to say, we understand the analogies, and to some extent there are similarities between this new digital environment and the old analog environment. But we shouldn't just assume that the similarities outweigh the differences, and we shouldn't assume that the old rules are the place to start in terms of the rules for this environment. And so it was interesting in the way they looked at it, because they looked at it and said, let's go back and see what was the policy that was underlying the first sale doctrine in the analog world, and is that policy the same, those policy objectives that hold in the new digital environment, right? It's a good question to ask in this environment, right? Professor O'Connor maybe raised a good question. He says, when you're looking at that question, maybe you should go back and look about whether that policy really even held in the old world, and especially now does it apply in the new world. And then let's think about what the other differences are in light of that policy, right? The Copyright Office, in looking at the digital first sale question, looked at it and said, okay, there are some important differences here. If you look at the analog technology, there were certain things that allowed a first sale doctrine to coexist with the rights of authors, right? That when you checked a book out of the library, you had it for a week or two and it was actually absent on the shelf. And if you return it, and it may not look as nice and pretty as when you checked it out, and it may not. If you look at a used book market, people might not be as attracted to a copy that may be missing a page or may be marked up in a place. And there were certain amounts of friction that the analog world created that the digital world didn't, and that affected the calculus about how the balance was struck in terms of the interest between the policies underlying the first sale doctrine in the analog space and the interests of creators and the overall objectives of the copyright system. The other thing that they said was, let's look and see in terms of what the attendant costs and benefits are, right? Some of those costs are looked at in terms of some of the anti-piracy questions they were looking at, but then they also looked at the fact that there are certain benefits with a new model. So in the digital first sale context and looking at the sort of old traditional questions, it was looking at it and saying there are benefits to a consumer that come from a licensing model, right? It used to be that you bought a copy and you had a copy and there were only certain things you could do with it. And buying that copy also gave you the ability then to dispose of that copy, which may be a benefit, but it also didn't allow you to move it onto a different device, and it didn't allow you to have it in multiple places at once, and it didn't allow you to transform it in different ways that you might find advantageous. And you looked at the digital context in a licensing model, and all of a sudden consumers could do a lot more with the media that they were consuming. And so you had to weigh those balances and say, is that actually more in line with what the consumer wants in this space than imposing the old rules, right? So the Copyright Office in that context, I'll just read, sort of in wrapping up, I'll flag one thing we come back to, but from the Copyright Office report, I think this frame is helpful for how we look at this question now, right? So the Copyright Office in that report said, reasoning by analogy always carries with it the risk of becoming captive to the analogy. Assumptions that are implicit in one situation can carry over to the analogous situation even though those assumptions no longer apply. This appears to be the case in the analogy between distribution of tangible copies and online transmissions of works. And then going to the consumer benefit question, they say proposals for a digital first sale doctrine endeavor to fit the exploitation of works online without a distribution model that was developed within the confines of pre-digital technologies. Digital communications technologies enables authors and publishers to develop new business models with a more flexible array of products that can be tailored and priced to meet the needs of distant consumers. Requiring the transmission of digital files be treated just the same as the sale of tangible copies artificially forces authors and publishers into a distribution model based on outright sale of copies. And then it goes on to conclude, and it says, if this sale model continues to be the dominant method of distribution, it should be the choice of the market and not due to legislative fiat. So I think that's the frame that I like here, is to look at this and say, how does this work? What do consumers want, right? If a first sale model makes sense in the metaverse, it ought to make sense at the end of the day for consumers. That ought to be what they demand, as opposed to just because we took sort of a square peg and tried to put it in a round hole. I'll flag one other issue that we can talk about as we go on. I think that it's worth also thinking, Dale talked about enforcement and how you enforce these rules. I think some of the old models that we ought to look at and see how they affect here go to liability and to incentives. I think we've come up in copyright law has a rich history of things like premises liability, right? And trying to figure out whether or not you treat something under a landlord-tenant model or whether you treat something under the line of dance hall cases, through the concept of right and ability to control and a direct financial benefit. Those are all frames that are actually pretty good frames in terms of thinking how you treat these liability issues in a metaverse environment. But we also adopted a bunch of safe harbor provisions that put those considerations in some cases to the side and create a different set of incentives. And so one question we ought to look back on is, do those rules actually fit the model in the metaverse space?
A lot of great questions. Thank you. Our next panelist is John Garon, who is professor of law and director of the IP Cybersecurity and Technology Law program at Nova Southeastern University Shepard Broad College of Law. John has been writing in this space since even the early days of when folks had no idea what this space was or how to define it. And he had to really jump through a lot of hoops to make the timing work today. So I'm really excited that he's here.
Thank you very much. And I'm not sure if the mic is on, but there we go. And you can hear me now. So many thoughts, so little time. I'm not really sure where to start. I promised that I would talk on some intellectual property rights. So let me just briefly note that in addition to copyright and trademark, there's also trade secrets, where I don't know that any of us are going to talk about in detail. But I'm very concerned about publicity rights. We see already in both the AI space and the metaverse space, and it's really hard to write in one and not write in the other. So please check out my stuff on SSRN. 2 articles on the internet on AI, 2 articles recently on the metaverse. But we see already a lot of commercial use of celebrity and athlete imagery to sell products or to sell apps. There's no doubt that we're going to see Mickey Mouse walking as somebody's avatar through the metaverse, but we're also going to see Gal Gadot's version of Wonder Woman. And in fact, if you ask ChatGPT for certain iconic characters, such as Frankenstein's monster, right, you're going to get Boris Karloff's image of that monster. If you ask for Wonder Woman, you're going to get Gal Gadot's imagery, not the imagery from the comic books. And so there's a question from the ingestion side, to what extent the publicity rights, the actual imagery of those individuals, has actually been incorporated into the AI model itself. And certainly from a production side, we see a tremendous amount of that already going on the internet with AI, obviously deep fakes and the weaponization of that in terms of unauthorized pornography, what is sometimes referred as revenge pornography, and other kinds of synthetic media. So that's just one of the issues. I know that this is an IP program, but I want to sneak in my larger concerns before we get back into IP. We know, again, from both fields that there's a tremendous concern about algorithmic justice and the ability of having framing to really have inequities. A lot of the costs, if we're talking about a $3,500 lens system or even a $500 lens system as the gatekeeper, means that we're going to have significant social inequities as to who's online and who's not online. If we're moving to a world of digital twins where social services, government agencies and the like are increasingly moving their better services into a metaverse environment, then only those people who can afford those technologies will have access to the social services. And that's not a stretch. I grew up with what was called free television. There was this thing called broadcast. Today, the average household pays over $75 for the now cheaper streaming services rather than cable. And if I read the headline correctly, Google was just forced to stop advertising that its online streaming service is cheaper than cable because at over $80 a month, it no longer is. Right? So we've seen tremendous price walls. When I was a kid, the notion that you could take a public sporting event like a baseball playoff and put it behind a paywall actually led to congressional hearings. Today, none of those content services are available for the general public. And someplace between 20 and 35% of the public has no access to this social binding content. As we build a successful metaverse, we have to be very mindful about who's included and who's excluded from that process, not just at the paywall, but also in the kind of activities, the kind of environments, the kind of avatars, what avatars will look like in terms of the range of designs that are available to represent oneself. We're in that space. Secondly, it is fundamentally different from a privacy standpoint. Research suggests that because we all type uniquely and we move our mouse uniquely, technology can identify an individual once they have gone online into a metaverse environment in roughly 15 seconds. And that's not using your ISP or the technology footprint of your device. And of course, every computer has its own digital fingerprint because of the configuration of software and hardware. So that's separately identifiable as a unique item. And then your behavior on any generic machine is immediately trackable. We know that there are already huge data warehouses that track all of our commercial activity and online activity. But since everything is mediated online, there is no way to separate oneself from the tracking that goes on in that space. I'm going to, if I end up having time, talk about the different metaverses. I prefer the term multiverse. Nobody else does, so I'm stuck. But in the multiverse, there's going to be a very different user experience for work and training related services, where we already see tremendous success of the metaverse or its versions, right? Military has been using this technology because it's a lot cheaper than an F-16 fighter jet. And so there's already been a lot of use cases in the military. There's a lot of use cases in industry training and education. It opens up great opportunities in public K through 12 education and collegiate education. There's all sorts of wonderful opportunities. But obviously that environment is a very different environment than the commercial social environment. And so we're going to be likely separating those spaces out. But the tracking issues, the privacy issues involved in each one of those metaverse environments is going to be very important to think about. Third, and totally unrelated to the top, is the fact that all of this is done through a third-party vendor. And if one remembers their constitutional law and their Fourth Amendment, there's something called the third-party doctrine. And the third-party doctrine means that any piece of information you buy from that is shared with a third party is outside of Fourth Amendment protection. So all the tracking that I just described is potentially available for law enforcement to purchase about us and thus utterly erode traditional Fourth Amendment protections. And so, again, right, the metaphors have to change because I don't think we mean a world in which we have dropped Fourth Amendment protections simply because we have new companies. Supreme Court has had a couple of cases where it has started to shrink the third-party doctrine, but it has not reversed it. And so there needs to be either statutory work to limit the purchase power of government to track its citizenry. And to illustrate that, one of the most successful metaverse environments that exists in the world right now is the Chinese model of the metaverse. So China has invested very heavily in metaverse technology, but it also uses what we call a social credit scoring system. And in China's social credit scoring system, if you are a good member of the party, you help your neighbors, you walk your dog, you clean up after your dog, that was a huge issue, and you are otherwise seen as responsible, then you get additional benefits. And those additional benefits may be additional vacations, easier access to airline tickets, hotels, and the like. If you are on the other side of that social credit system, already in China, you can lose the right to send your children to universities, you can lose the right to travel on airplanes or even purchase train tickets, or lose the ability to rental units in various communities. So having that tracking power, we're already seeing demonstrated, has all of these consequences. And then the final piece is the contracts. We've already started to talk about the contracting from the click-wrap side, obviously from a labor and employment, since we're talking about a work metaverse as well as a commercial metaverse. A policy that is a no disparagement clause will probably violate Section 7 of the Unfair Labor Act because you can't have restrictions on aid comfort within, whether you're in a collective bargaining unit or not. So there's going to be additional limited protections to some employees who are interacting in the metaverse. We've seen that in social media. But I want to go back to where Dale reminded us about the contracts. There's a large contract stack. It starts with either Google, Amazon, AWS, or Microsoft, because the cloud AI is going to fuel a lot of activity within the metaverse, and those are the only three companies that have the bandwidth to run that kind of service. So it's going to be from one of those three entities. It will then contract with the ISP. The ISP, which hosts it, will then contract with the Metaverse publisher. That's the Decentraland or the Horizons or the company that's creating the Metaverse. The Metaverse publisher will likely not control all of the activities, right? So this is where virtual real estate comes in, which, by the way, is a terrible metaphor. It's not real estate. It's basically a trade show booth. It can be moved around, it can be closed, it can be devalued. It is not real estate, and it's not about location. But so that contract then, that sub-vendor will have an end-user license agreement with every consumer who comes into that particular space. So when we look at the terms of service, right, everyone in the stack can only provide those services that the company above it in the stack permit under its license agreement. So there is choke points at the ISP level, at the vendor level, as well as at the booth level in terms of what's going to go into those terms of service. We've talked about the old days. So in addition to those early conversations about Section 512 and some of those transformations, right? Some of us still have scars from the discussions over Article 2B and the need for a consumer protection law. The UCC has just passed Article 12, so for those who are familiar with it. So the notion that we have at the state level recognition of digital assets, either through the owned electronic records of Article 12 or through the Fiduciary Act that was passed or updated a few years ago so that there's a way for fiduciaries to control the digital assets. The economics of digital assets within these spaces and how interoperability may or may not exist, how portability may or may not exist within these spaces for those digital assets can't be answered by copyright alone, because copyright ignores a lot of consumer protection considerations. But some combination of what Counsel is looking at, some combination of what we learned in history from Article 2 and its failures, as well as the consumer drivers, are probably going to shape what this looks like. It's not going to be easy, and it's not going to be quick. Thank you.
Great. So we are in the multipurpose room talking about the multiverse. I told you it was going to be sprawling. We got a lot of ground to cover. Our last panelist is Daryl Lim. He is the Laddie Montague Jr. Chair and Associate Dean for Research and Innovation and Founding Director of the IP and Innovative Initiative at Penn State Dickinson Law. And he's also a Senior Scholar at CIP2. He has really deep expertise on this topic. And he also is, I think of him as kind of a generalist whose work is really broad in scope across domestic and international IP. So, Daryl.
Thanks, Alex. I should get you to be my PR agent. It's a pleasure to be here, especially because, as Alex mentioned, of my affiliation with the center, and before that, I was also a Edison Fellow. So that's in North Carolina, they call them double Tar Heels. I think we have to find something that's equivalent. I'm going to be putting myself in the position of a trademark owner for most of my remarks, and I see Jenny Simmons in the room, so I'm going to. This one's for you, Jenny. Jenny's from INTA. So I'm going to focus on three topics broadly: management, maximization, enforcement, and localization. So what are we talking about when we think about management? Well, the key issue here, I think, is what's called the normal evolution of trademark use, whether virtual goods are within the normal evolution of the analog equivalent, and we heard Dale talk about this briefly earlier. Well, the TTAP has historically taken a relatively narrow view of extended coverage based on tacking or natural zone of expansion. But in April of this year, I think we got additional guidance from the Court of Appeals of the Federal Circuit in a case called Patini versus Apple. This is not a case related to the Metaverse, but it did make the point that extended coverage requires new goods to be within natural or normal evolution of previous goods in the existing channels that trademarks protect. Now, so what does that mean then in terms of the metaverse? One possibility is you look at the normal evolution in terms of functionality. And in the Rothschild case that was mentioned earlier, one of the issues was whether or not the trademark was used expressively or whether it was used to identify the goods and services, in this case, the product. And so if you have a trademark on a virtual good without functionality, it's more likely that it would be considered expressive and not eligible for trademark protection. And so if you can draw a link as we see technology advancing in the metaverse space, you may have more and more applications of goods and services with that functionality in mind, and that's more likely to draw the thumb on the scale towards a natural evolution, a normal evolution of the mark. So that's with respect to management. What about maximization? Well, maximization, the key issue here, I think, is licensing. So you have brick-and-mortar trademark owners thinking about licensing as a means of extending their coverage in the metaverse. And what are some of the things that you need to think about in terms of those licensing terms? Well, first of all, I think you need to think about scope. You need to clarify what is covered by the licensed goods and the virtual goods. You want to be also careful in not artificially limiting yourself in the virtual space in terms of the scope of coverage in a way that you might have to do in a brick and mortar space. Second thing you might want to think about is your product expansion plan. Oftentimes when a trademark owner licenses the mark, there is that question of controlling or still maintaining some type of control over the licensee. And naturally that happens in the brick and mortar space because supply chain issues, manufacturing capabilities are more limited. In the metaverse, everything is instantly reproducible. Therefore, I think when you think about the licensing terms, it's important to put in some type of licensor approval right. And third, I think it's important to think about quality control because a trademark owner is required to exercise control over the quality of over the licensee's use of the license mark. So in doing so in the metaverse, I think it's important to think about the specific virtual good guidelines. And I think over time, once again, you're going to develop some types of norms for that. In also thinking about maximization of IP assets, I think it's also important to look at copyright law because unlike with trademarks where you need likelihood of confusion, you have that tie to particular stream of goods and services. With copyright law, you are not quite so tethered or not quite so restricted. And I think the derivative work right has tremendous potential in the metaverse. Thirdly, enforcement. I think the key issue there, again, I think we heard from Dale, is anonymity. In the metaverse space, you have difficulty in tracking down who exactly is doing what. Singapore actually provides an interesting case study. You might have heard of this case involving Bored Ape, the Bored Ape NFT. The owner of the NFTs was not known, but the court was still able to order an injunction against the use of that mark, and because the marketplace was known, OpenSea, the marketplace was known, and so the court was able to order an injunction against that mark. Another difficulty with enforcement is that with NFTs, you need to provide a private key in order to effect a transfer. And so you may have difficulty, even with a court order, unilaterally mandating that transfer of that private key. Or indeed, how do you stop the further transmission of the NFT? One way to do it is you use the brick and mortar analog. Well, in the brick and mortar space, what you do is you ask for the tools used to manufacture those infringing goods to be destroyed. One possibility here is you could require the issuer to delete the underlying asset to the NFT. NFT is linked to the underlying digital asset, usually an image, and so you can have an injunction that's sought against the host of the digital image. Another thing that's something important to think about in terms of enforcement is the presence of the First Amendment defense. with NFTs. With trademark law, we know that the courts take a very broad and robust view of the First Amendment defense. Cases like Mattel versus MCA come to mind, where the court upheld a non-commercial use exception for Aqua's Barbie Girl song, because the song lampooned Barbie's image and comments humorously on the cultural values Aqua seeks she represents. I think, if nothing else, the latest movie probably amplifies that even more. And I think it's also important to recognize that the U.S. is, in a sense, an outlier in its very robust view of First Amendment rights. And when you think about the practice overseas, it may be quite different. Which brings me then to the fourth and final point, and that's localization. And it's important, I think, to recognize that the situation in the US and the metaverses related to the US may be quite different to the situation in China or somewhere else. In this regard, I think it's helpful to think about the evolution from Web 2.0 to Web 3.0. And you still have certain things that you can draw upon. So for example, even though you have in the metaverse cryptocurrencies the lack of top-level domain names and physical shipping location, you still have apps which you need to download the metaverse software from. So you still have that tether. You have language, and you need to choose a primary language for your own metaverse experience, despite the fact that there are automatic translation tools out there. And finally, you have currency. So even though you have cryptocurrency, but cryptocurrencies need to be purchased, first of all, using traditional currencies. So there are these Web 2.0, shall we call them, analogs that we can still look at as we navigate this space. But in looking ahead, I think it's important to think about two overarching themes. The first is that we are moving from individual siloed metaverses into what's probably a decentralized version of a metaverse across different platforms. And it's not clear that the laws that we have, especially with respect to the localization issues and enforcement issues, are sufficiently robust to deal with that. The second theme, I think, is really the intermarriage of some of the cutting-edge topics that we hear about at conferences. So think, for example, about what happens if a digital avatar that uses artificial intelligence to create something that is printed on a 3D printer. What sort of IP issues would arise in that case? So I think that the ground is ripe for many future discussions like these, and I look forward to those that we're going to have today. Thank you.
All right, great. I didn't mean to keep you from clapping. I wanted to jump right in with some questions for further discussion, and then we'll open it up shortly to the audience. So first, the broader theme of today's conference, of course, is first sale and also its limitations. So I wanted to ask the panelists, how should we think about first sale in the metaverse as a defense to an allegation of copyright or trademark infringement? So does the metaverse require a more robust, expansive understanding of first sale, or conversely, is first sale kind of less likely to shield metaverse uses? So we need a narrower conception, because those uses constitute material alteration, or because they actually do cause confusion, or they exceed the bounds of physical or digital first sale due to the nature of online use and sharing, or is that not a question that can be answered because use to use is just so different? And, I wanted to tie in kind of, Troy, you mentioned this idea of friction in the analog world that's not present in the digital world. And I'm curious about the interplay there with first sale. And then Daryl, quality control, quality in general, control in general, where first sale kind of generally means relinquishing control, right? So how do we think about first sale in the metaverse? Welcome to jump in any order.
Go first. Okay, so I'll pick up where I left off, right, which is what the right frame is to look at this through. And I think, to me, you go back to the first sale doctrine and its origins, right, which is as an aversion to restrictions on the alienation of chattels, right, or maybe certain types of chattels, right. And what does that mean in the metaverse, right? So if you boil that down, at the end of the day, does that mean that if I buy a sweater in the metaverse, then I ought to be able to give that sweater away, to destroy it, to sell it? That's probably all that it means, right? I'm not sure there's much more to it than that. And so then I think the question is, okay, well, then how does that compare to my concept of being able to do that in the real world, right? Well, if you're looking at that from the concept of copyright incentives, sweater's not a good example, right? It's not an expressive work, so let's think about an expressive work, right? So if I buy a book in the metaverse, or a poem or something like that, the traditional frictions that apply in the real world probably don't apply in the metaverse, right? There may be some analogies that are more equivalent in the metaverse than they are in just sort of like the true digital first sale doctrine. You might have a library in the metaverse that I might be able to check something out and it sticks with me, and you're not really talking about a frame where it's being checked in and out and in and out and in and out in a way that doesn't resemble a normal library. But on the other hand, all these things about why people prefer new versus used, dealing with scarcity, dealing with the durability of the product, none of those things seem to apply in the metaverse, and so it doesn't seem to be a very good analogy. The other question then comes, okay, well, what are the alternative models to a first sale doctrine in the metaverse? And I think in terms of what the benefits are of a robust metaverse that involve a relationship between the copyright owner and the person who purchases or who licenses, who consumes the copyrighted work. And so I think of an example. I think I've talked before about what if you go into what if you go and you visit Disney World and you go into Saba's lab and you create your own customized lightsaber, and when you do that, you have the opportunity to get a digital version of that can be yours in your metaverse, and then you can use that, and you have the ability from there to when you're watching in your home, you're watching a Star Wars program, to all of a sudden see your character appear in this story somehow in an immersive way with your lightsaber that's unique to you, right? Those are all things that might be possible in the metaverse, right? But they're all possible through an arrangement that's much more than just the sale of a good, right? There's a licensing relationship there that's going to govern, that's going to include in terms of use, and there's a certain amount of scarcity that's going to be involved in making that model work, right? I mean, my ability to go and get that lightsaber that's unique to me and then take it in these other places that's going to have less value as an offering if that then can be just passed around to other people, right? There's no more incentive to actually go and visit the park and to create my lightsaber if I can just pick it up in the metaverse. So I think there's a vision of the world that is very robust, that exists in a world in which the first sale doctrine as we know it isn't the rule of the metaverse. I think in some ways you could apply the traditional metaverse, the traditional first sale doctrines to the metaverse, but I think the benefits you get from it in that context are limited. And at the end of the day, I think how this shakes out is really going to be, does the consumer care? How much does the consumer care, right? Does the consumer care more about the ability to get a lightsaber and sell it to somebody else than they do about the other benefits that come with the model that's made available where that option isn't included in the terms of use?
So just to kind of amplify on that, I just don't think the first sale, and I could be wrong, fits well with the metaverse legally or practically. So legally, we know that in the cases like Redigi, the reason people couldn't have first sale there was because it wasn't like I was selling my comic book. You were making a copy of it in order to sell it to somebody else. And that's why the Second Circuit said that you couldn't do that under copyright law, that a copy was being made. It wasn't like selling an object. Now, in trademark law, theoretically, that same concept wouldn't apply, right, as a barrier, because I'm avoiding the copying concept. And so theoretically, in trademark law, well, maybe that could be different. But that gets to the practical point. Remember, all these things, these metaverses are computer constructs by very smart people, and chances are they're going to have to come, if they wanted to allow you to buy a virtual good and then resell it, they're going to have to engineer it to permit that, because they may not want to engineer it to permit that. It could be very expensive and confusing for them to engineer it to permit that. Plus, which then that might create this other market as opposed to getting new fresh goods from one of their customers, one of their vendors, or from the company themselves. So maybe somebody else will come up with a competing service that does allow that. Maybe everyone will flock there. I don't know. But as a basic matter, I don't think you should just assume that the technology will be set up in a way to make it easy for you to do that. If it did happen, I think Redigi would apply for copyright, and there'd be different issues with regard to trademark, with regard to will people understand that that's just me selling my copy of Captain America #1, or is it someone thinking that, oh no, somehow this was affiliated with Marvel in some kind of way that would make that confusing?
So I don't think I really set out when we had this conversation to become the consumer advocate for the bench, but I'll play that role at least for now. In my writing, I'm a little bit more nuanced, but we're not really hearing that, right? So 15 years ago, I think it was already, again in China, a young man murdered his former roommate because the former roommate stole his $500 magical sword and sold it in a video game. I think people care very much about the digital assets that they've accumulated. My mother-in-law passed away a number of months ago, not that many months ago. She had over $2,000 worth of Kindle mystery books that disappeared as a result of the transition, right, and didn't become part of her estate. She was a voracious reader. Not only did the access to those titles, which had been paid for, and as a consumer, you expect that that has a residual value, but right for my wife, the fact that my mother-in-law had collected them had a personal meaning. So we see in the Fiduciary Act, right, that almost every state has adopted a law that strips the ability of vendors to stop the transfer of those assets, right? Because state legislatures recognize that there's a tremendous interest in those assets. I don't think we have a diversity in the marketplace yet of proto-metaverses and gaming companies such that we can say there is a sufficiently robust marketplace that very different rules of exchange exist. And so the marketplace, people can choose to buy their books from, I'm not sure, is there any other companies other than Amazon that sell books anymore? But right, if there is, if Barnes & Noble still exists, I don't think their online division really does. But if they did, maybe they would have a better marketplace for consumers. But we really haven't seen that. We have seen parallel play. And so the same rules apply in the Apple bookstore, the same rules apply in the Barnes & Noble bookstore, such that I don't think we can really feel that the marketplace is going to apply for this. Instead, what we have in a metaverse that is incredibly trackable is we finally have the ability to implement a forward and delete technology that actually guarantees that when I say I'm moving a digital object, my computer knows that I have relinquished access to that object, and therefore it cannot operate within my profile. And so the transfer is certainly analogous to a sale or distribution, right? So forward and delete is a technological solution that matches it. And we also see from the Copyright Act, right? The first sale doctrine is not absolute, right? So when we saw record stores starting to do record rentals and software companies doing software rentals where you could pay $1 and take out a commercial product that got downloaded into your computer, copied, and then you bring it back, right? Copyright law was amended to make sure that that commercial exploitation was stopped. So there's no reason we can't go the other way and say, right, enforceable forward and delete is the alternative. And while, Troy, you're absolutely right that there is friction involved with, right, when we went from analog music to digital music, right, your cassette tape degraded over the number of copies, and so we had some degradation. But the real issue from a commercial standpoint, quite frankly, is staleness, right? The long tail never emerged. Works are incredibly popular when they come out, and that tail, for most works, diminishes very rapidly. Now, obviously, in the children's market, that's different because there's already always new children, and Disney has been brilliant about creating limited exclusivity and maximizing that opportunity. But for most authors and creators, works tend to have a lot less sales after the first 6 months, certainly after the first 18 months. And so while it's not quite the same friction, it's close enough to create a marketplace that protects consumers for their investments, while at the same time protecting creators and their uses.
Thanks. So Alex, to answer your question, I think with respect to quality control, it's probably not so much a trademark a first sale doctrine issue, to the extent that quality control is there. The concerns are what can you mandate in a license, and then can you actually meaningfully enforce them in the metaverse. When I think about first sale, I think more in terms of copyright and patent law. And if you look in both areas, I think the laws has been greatly weakened by jurisprudence in the copyright space, like Werner versus Autodesk, that basically regards every, you can't even call it a sale anymore, a license, a use of software as a license. And in the patent space, you think about the Monsanto and Bowman decision, where because of the concerns about protecting the Monsanto's business proprietary model. Is my time up? No. Okay. Against self-replicating technologies, you have essentially a never-ending stream of controllable products downstream, and so first sale is effectively extinguished in that case as well. So I think, given the trend in both of these spaces, when you look at the metaverse, I think eventually you would see a non-existent first sale doctrine. And for companies, for games like Fortnite, for example, right, it's fine because the terms and conditions allow players to buy and sell stuff within that limited metaverse. And because unlike in the real space, in the metaverse, everything can be added or deleted with a click of a mouse. So there's no concern about arbitrage in the way that you would have in the real world. It's a lot easier to police, let's put it that way. But that's only today. We need to think about the metaverse of tomorrow. And as I alluded to in my closing remarks, I think the day will soon come where tech companies are going to talk to each other to say that they can maximize the value of their assets much more effectively if they join hands across different spaces. And you can, I think the person leading the charge in this space is Mark Zuckerberg, of course, that's rebranded his entire company to push that vision. And in that space, I think you're going to rely, at least initially, more on private ordering between companies. And perhaps that's not a bad thing because companies are well advised by legal counsel most of the time. And then it becomes up to the consumer whether or not they want to be part of that transaction. But I think eventually you might have then a need for courts to step in, or a need for Congress to step in to protect the consumer in other ways, or the FTC to step in perhaps when there are unfair, deceptive practices or antitrust abuses. And then you will have further reordering of the landscape. And I think that will effectively achieve the same type of result that a first sale doctrine would in the analog world, but it will be by a vastly different route than what we are familiar with.
Great. I would love to open it up for audience questions if anyone has one right now.
Hey. Okay, go. Thank you, everybody. This is fascinating discussion. Though I have to confess, I'm still sort of struggling to wrap my head around the initial question that Dale raised, which is, well, not so much what is the metaverse, but also to what extent does the metaverse differ from just digital technology in general, right? We've had 20 years, roughly, give or take, of struggling with, trying to make the types of analogies that Troy was talking about and trying to figure out, how to make them properly between what we're used to in the analog world and what are the new challenges for IP law that a digital realm, requires us to confront. in that realm, we've already got, massively multiplayer online RPGs, and, we've had World of Warcraft for a long time now. So we're already used to immersive environments that might have their own internal currencies and their own object, property right, or at least objects that people might, scarce objects that people might want to own, acquire, transfer. And so what I'm trying to understand is when I hear this word metaverse, basically I just think, oh, that just means websites plus 3D goggles. And maybe I'm missing something, but what I'm trying to understand is, are there any specific attributes of whatever this thing is that you're calling the metaverse that add new IP problems that don't already exist in just what we now call the digital online world? Is it just sort of taking it to the next level because we're getting to a point where those online immersive environments are going to become more and more prevalent? I mean, obviously the term metaverse comes from Neil Stephenson's Snow Crash, and he was imagining a world where basically anytime you went online, you were wearing goggles, and it was like you were walking in a virtual city, and then different websites were like locations you would go to, something like that, right? Where you actually had a persistent online avatar presence. I mean, and even if that's what I'm trying to imagine, what attributes of that is the move from just regular digital online world to metaverse a category change, or is it just sort of a question of degree? I'm just curious, to what extent does this topic raise actually new issues?
Well, I mean, part of the answer to that question is, does it matter? I mean, because there's lots of things. I mean, to me, the metaverse I want to go to is the Star Trek holodeck, right? Where you're not wearing goggles and you can go there and hang out. And that would be cool. Or I'd want to live at Walt Disney World with my kids who would never leave, which is scary. And have whole things like that, and have Dumbo fly away with us, that kind of thing. I mean, would be all these cool things that we would want. I don't know if it really changes the IP issues that much, though. And yes, there could be special laws created. There could always be fine-tuning of laws, and DMCA was created, and I can see all that. But I think largely it is a question of degree, and I think you then need to look at it from an IP perspective as to what is your goal and who's being injured and whose ox is being gored, if anyone, or is this some amazing, wonderful, fantastic marketing tool that people are into? And I guess that's one thing I want to say, because we've been asked to talk a lot about enforcement, but a big thing about the concept of the metaverses these days, at least from a lot of my clients' perspective, is how they want to participate in it. Is this going to be like, many, many companies, they're not named Meta or Facebook, but they have Instagram pages, and they have, or YouTube sites and stuff like that, right? They're participating. And so, a lot of folks are trying to decide, do I want to participate about using my own IP? And I hope they do, because I really want to have that Star Trek holodeck experience someday.
So I'll give a slightly different perspective. It's all analogies. So one analogy is Pruneyard Shopping Mall, right? So when suddenly we jumped from Main Street and malls to the court saying a mall is a main street, the law broke for 20 years until the Supreme Court said, California, we didn't mean it, and we want to pull back that notion that a private commercial mall has the obligations of a public space, right? We have had a host of people suggesting that's true of social media, including the states of Texas and Florida, and so those cases are up before the Supreme Court right now. From a copyright standpoint, I think it's less of a leap, but there's still something of a leap when not only, right, so when I do this talk, I have a picture of the African American Museum of the Metaverse. And not only does it have licensed artwork images that are within the space that obviously whoever is the vendor for that museum had to license from the artists and in turn get a license from whichever metaverse that space exists in, but somebody else had to draw the plants and the walls and all the utilitarian objects that are in the real world that we had suddenly copyright attaching to in the virtual world. So there's a new level of engagement. But in my article, what I really focus on is the ubiquitous metaverse, right? It doesn't matter when it is separate. But as it becomes more and more the medium with which commercial activity takes place, right? Think about if we had lived in a world where Zoom claimed copyright of all of our speech in all of our meetings, in the same way that our game companies claim the copyright of all their players in those platforms. So we have restricted, during the pandemic, the intellectual property reach of our platforms. But we're developing a game-first, commercial-first model that is, right, you're here as a consumer as a service, not we are a vendor supporting your service. And the difference between Zoom and Fortnite is tremendous if you think about opening your law practice online.
Let's go back to the golden days of yesteryear. There was a company called Second Life. It still exists. It started in 2003, and I became a little interested in how it was working, so I joined up. And in Second Life, you could buy paintings using Linden dollars. These were original paintings. It's always confused me as to what I actually bought. I'm not quite certain I bought anything. It was an original work of art. I guess it could have been copyrighted. I could hang it on my virtual wall in my virtual condo. I have no idea what I was buying. There were people performing musical concerts. I have no idea whether there was a copyright issue there. They were playing original music. They were playing other people's music. Clearly there was a performance, but was it real? I don't know. I'm trying to think. There were trademark issues. If you file a trademark application and it's in use in a virtual world, is it in use or is it intent to use? I don't know. The whole thing was sort of the Wild West in 2003. The avatars too. This should interest our Disney representative. There were Disney avatars. And these were not created by Linden Labs, who ran this thing. This was created by the participants. Was there a trademark violation? Were there copyright violations? I don't know. In hindsight, we didn't know very much of what was going on. We didn't know what we were purchasing. We were purchasing property with Linden dollars. We didn't know what time it was because we were using Linden time. It was a very strange environment. Maybe you guys can clarify. Has there been some evolution in the understanding of that Second Life universe that you could key me in on?
Well, there hasn't been as. I'll say this because I almost talked about this case, but didn't have the time. There hasn't been there used to be, just like there's this panel 20 years ago, there were a million Second Life panels, and INTA had whole committees on Second Life and all the rest of it. And the thing is, commercially, it didn't become as big as people thought, maybe, but there wasn't as much litigation. There was a big case, if you wanted to look at it, called, what is it called? It's called Bragg versus Linden Research, Inc., 487 F sub 2nd 593. But it wasn't about these kind of IP issues that we're talking about here. It was more about concern, similar to what John was talking about, that a guy was his transaction that he cared about was his account was frozen, and he was really upset, and he wanted to have how dare you take away my rights, that kind of thing. And most of the case was just about the enforceability of the terms of use and choice of law type issues. So the bottom line is Second Life did not solve all these kinds of trademark and copyright and enforcement issues, and it's an early stage of some of this. You also asked about, do people do ITUs, intent to use applications? They often do file now intent to use applications on the premise that they might use something virtually, but there's a question though, like if I had someone I don't represent, if I have a Ferrari and I have a car Ferrari and there's a virtual Ferrari, do you really think that's not connected with the other Ferrari? And so there's a debate as to whether you need those virtual trademark registrations. But in general, better to have more trademark registrations than not to have trademark registrations. So I don't know if that kind of dealt with some of your questions, but Second Life is a thing. It's still a thing. But it hasn't solved, there hasn't been a lot of cases on it.
So I'll just add one point. When looking at Second Life and some of those early companies, particularly from a trademark standpoint, trying to, as Daryl highlighted, right, there's a huge First Amendment, right? This is a communicative platform you're creating, you're engaging, and so there's a First Amendment overlay. And so one possible way of thinking about it is how close to a commercial transaction are you, right? So if you can click on that Ferrari and it brings you to a Tesla dealership, they don't actually exist, but if it brought you to a dealership of an automobile company that wasn't selling Ferraris, I think you have a much clearer trademark infringement case than if it is simply, a cool car that you're driving around as a status symbol and you are using it in your personal storytelling and not in any way to commercialize that Ferrari. One of the other ways in which the metaverse world is different from every other world is that everything can be clickable into a commercial transaction. Every piece of clothing that's on your avatar can go to either a virtual clinic to dress your avatar or to a physical shop. So you go to Land's End and buy the clothing that people's avatars are wearing. And that commercializes a lot of what didn't used to be commercial activity.
Hello, thank you all for being here. I apologize for my ignorance as just a layperson, but I've been thinking a little bit about some of the comments on scarcity versus equity, as well as consumer and corporate demands and needs. How do you anticipate going forward that will be balanced if, for instance, let's use a hypothetical of if I want to recreate my bedroom in a digital space, there may be copyrighted works in there, such as a poster of a band or maybe that lightsaber I made at Disney World. If I'm going to create that then in a space owned by Meta or any other company for that matter, how can all of those overlapping needs and interests be accounted for, while also, as Professor Garon was saying, allowing for previously marginalized groups or groups who may not have access to the resources even to participate in these spaces to create an accurate representation of their reality while still making sure that everyone who needs to get paid is getting paid?
Well, all right. As we all jump to answer that question, it's a really good question, and it's a hard question because the real answer is I don't think any of us know. Now, it might be that things could be. You probably know that things like fan fiction, fan sites are given broad freedom by many folks to do a lot as long as you don't start selling things. I had a Harry Potter lexicon case that was along those lines back in the day. So maybe the nature of a site will be the kind of thing that no harm, no foul, that's fine. Or it might be, as Professor Garon was talking about, that you're buying and selling things and you're causing confusion or you're interfering with somebody else's market, and then that might be a problem. The issue of whether you can replicate reality or not is a controversial issue, not just in the virtual world, but in films. Just because people might clear things doesn't mean they actually have to clear things. There's expediency. I'm litigating some video game tattoo cases. Is it copyright infringement to replicate the virtual reality of LeBron James has tattoos, to be in a video game looking like him or not? So, it's not a very helpful answer to the question, but do think about, when you're doing something, I would just think, gosh, is someone going to be upset and why? Is this really going to screw somebody? And if so, there might possibly be some law that you might want to look at a little bit more. I don't know.
With it being as trackable as it is, it's a little different than bootleg merchandise that you might see near Orlando, Florida, where that might be something where it just doesn't matter enough to follow up on that. But as you were saying before, who cares? It will be a lot easier to know how many people are abusing these things and for companies to suddenly say they care. So thank you. I appreciate your answer.
All right, great. We do have to call it. We are a little past our time, so I just want to thank our fantastic panelists again and thank our audience for joining us today.